All rise. The Court of Appeals Division 1 is now in session.
Good morning, I think. Be seated. This is the time we have set for oral argument in our CV140397, Breonna Tessler versus Progressive Preferred Insurance Company. Each side is allocated 20 minutes for argument. The appellant may reserve a portion of that time for rebuttal. If you wish to do so, you will need to keep track of time using the podium clock. The burden is on you. Out of respect for counsel, I'm going to ask anyone in the courtroom that has a cell phone to please make sure that it is off or on vibrate. I want counsel to be very clear. We have read the briefs, we have conferenced the case this morning, and we encourage you to keep that in mind so that you can best use your time in the course of your oral argument. These proceedings are being recorded and will be posted on YouTube. As you begin your argument, please state your name and the party you represent so that YouTube won't be at all confused about who you are. And counsel, if you would proceed.
Thank you very much. Good morning. If the court pleases, Larry Zyer on behalf of Breonna Tessler, appellant and cross appellee. In essence, this matter does not have a particularly rich factual matrix. It arises, as the court knows, out of a car accident. However, the crisp question now is whether recognizing the public policy favoring arbitrations, recognizing and conceding that arbitrations are an integral part of the process and generally are binding, whether the statute, ARS 12-1512, the Uniform Arbitration Act, requires, in connection with the reception of evidence, that uncontested and uncontroverted medical or expert evidence indeed be accepted as such by the arbitration panel.
I struggled to find any uncontroverted evidence. It seemed that there were diverse opinions.
Thank you, Your Honor. Our position is that Dr. Domer's supplemental report was made subsequent to his initial report, where he really, at least respectfully submit, was not particularly clear. He required additional information, which is why he obtained the additional information. He had the deposition transcript given to him by my learned friend, reviewed same, and bearing in mind that Dr. Steingart had treated Ms. Tessler for many years, and in fact was the surgeon who performed the surgery on her right knee, was able to shed some light on causation. Dr. Domer then came in his supplemental report, and as we read it, he said, to a reasonable degree of medical certainty, the motor vehicle accident was the cause of the surgery, in essence.
But isn't what Dr. Domer said, wasn't what Dr. Domer said that he certainly understood what Steingart was saying, that he respected his opinion, he just didn't agree with it? Isn't that what he was saying?
With respect, John, I'm not in agreement. If I may refer to Dr. Domer's supplemental report, he says that it does not alter my opinion to a reasonable degree of medical certainty. And if I may quote, finally, after reviewing his deposition, it does not change my opinion that the problems that she had in her knee and the subsequent surgery that she had in her knee could be said to have occurred to a reasonable degree of medical probability as a direct result of her motor vehicle accident in question. And so our reading of that is that that's crystal clear. Obviously, if the court disagrees, then I have no argument.
So as a result of his review of the transcript of the proceedings, he had basically kind of a revelation and said, I know what I said over here, but I've completely changed my position?
I'm not sure whether he changed his position. I think in his original report, he said he would benefit from additional information, specifically Dr. Steingart's deposition or examination under oath. And he said he would benefit from receiving some radiographic pictures. He said synovitis and the other ailments from which my client suffered were, in essence, difficult to diagnose and even more perhaps difficult to treat. To be sure, she did have pre-existing injuries. And so he expressed the difficulty, but I'm not sure whether the expression of the difficulty was disagreeing on causation. I think he couldn't form an opinion on causation. And I think when he came in with his supplemental report, which really is the climax, the summary, if you will, of everything which he'd reviewed and done on the case, he was crystal clear. I'm not sure how else to read those two things in conjunction.
So all the discussion earlier had about the fact that that Ms. Tesler had filled out documents indicating she had hurt her knee earlier, that she'd had ongoing problems, that I believe some 6 years before she had struggled with the problems with that knee. All of that went by the wayside, and it turned out to just, in his mind, then he isolated on just this accident being the causation?
I think that he did take those prior factors into account, which is appropriate. However, the case that we made was that the surgery was proximately and directly caused. In other words, but for the accident, the surgery would not have been necessary. I think that was really the question. He could opine on damages in the sense that there might have been pre-existing damages, there might have been pre-existing injuries. But if it's an eggshell plaintiff and he says, well, now there's an accident, some event happened, it was an acute event and a significant accident. I've read the deposition of the surgeon who actually performed the surgery. And now I've come up with my final conclusion, and it really is his final conclusion. I would respectfully submit that ought to have been accepted by the arbitration panel.
But you may actually be right under Arizona law that the arbitration panel should have done that. And the arbitration panel may have taken too inhospitable a view of eggshell plaintiffs in its deliberations. It may have been flat wrong. The problem is, and I'm not quite sure why there is such fealty to arbitration in our public policy, but there is, when arbitrators get the law wrong, there's nothing a court can do.
Thank you, Your Honor, and I would respectfully agree. This isn't a question of law, however, and I think the cases are on point and they are quite clear, particularly the Industrial Commission cases, where the arbitrators can get the law wrong, they can get the facts wrong in a certain sense, but they have to give proper weight. In other words, consider or hear under the two different statutes doesn't mean physical reception of the evidence or admission in the evidentiary sense. It means to actually give it proper weight. And by analogy, we submit that a court, a jury, any trier of fact, in a quasi-judicial official indeed, must give proper weight to uncontroverted expert evidence.
But we can't reweigh evidence in a judicial proceeding, much less in an arbitration. That's not a proper function of an appellate court. So how do we cross that barrier?
Thank you. I would agree indeed that the evidence can't be reweighed to the extent that it's conflicting. Obviously, if the court disagrees with my initial proposition that the evidence is indeed conflicting, then we don't prevail. But if, in fact, our expert, together with Dr. Doma, the defense expert, as a matter of fact, did not conflict, as a matter of fact, were expert witnesses and opined within the field of their expertise, then the statute comes into play, which does indeed allow for reversal or vacation of an arbitration award under limited circumstances. And one of those limited circumstances would be when the arbitrators fail to hear or receive or consider the evidence. And I think...
Well, but they received all of the evidence that was offered, right?
Indeed.
Okay. Physically, they heard it. How are we to know whether they considered it or whether they failed to consider it at all, or whether they simply considered it in a manner with which we disagree?
The arbitrator, Mr. Marks, Mert Marks, indeed, and as part of the record, sent an email, and he said that the arbitrators, the other two, his colleagues on the panel, flatly refused to consider this material crucial evidence, and it's uncontroverted. So if we give that weight and we actually look at the only documents with which the arbitration panel was presented at the arbitration, setting aside counsel's argument, then I think we can have somewhat of an objective view of this.
Well, lawyers accuse one another of failing to consider things all the time when they disagree with one another. Even judges do that. But that's sort of like relying on the dissent to establish an uncontroverted fact. And sometimes that use of the term "fail to consider" is imprecise, at least in the vernacular. I think the term, as it's used in the statute, is designed to suggest that the arbitrators simply refused the evidence. But for whatever reason, there was uncontroverted evidence available, and they kept it out of their analysis. Here, it seems that they have wrongly considered it. Or that's the argument, is that they've wrongly considered it.
Thank you, Your Honor. Our respectful submission is that they didn't consider in a way consistent with public policy and the statutes. In other words, the statute has to have some meaning. If we were just to say that they failed to hear or consider the evidence, then the statute could easily and ought, in fact, to have said admission of evidence. They refused to admit the evidence. The statute doesn't say that, and there's no case in point in Arizona on this issue. So to give some type of effect, some, I don't want to say teeth, but some real meaning to the statute, the arbitrators must have done something more. And I think by inductive logic it must be, therefore it is. Had they given any appropriate weight, to use the term loosely, to this particular uncontroverted evidence, then they must of necessity have given an award at least reflecting the surgery itself, which they failed to do.
But if Dr. Domer, not meaning to show any disrespect, if he said that what there was simply a transient increase in pain over a period of time arising from a problem with the knee that preceded any injury, just something that with time was going to reveal itself, but it was an inherent problem with the knee, and they accepted that, and the mediators accepted that. Couldn't they then refuse to accept any additional testimony regarding these aggravators that lead to the more vulnerable victim that you talk about? Isn't that their right to say, I'm not going to look at this because we accept the fact that there's this transient increase as a result of a problem that is not the result of any injury to the knee?
And I would respectfully agree, Your Honor.
I'm sorry?
I would respectfully agree with the court. In other words, Your Honor would be correct if on that hypothesis and with that example, the arbitrators indeed made that finding. I would agree with the court if that were the case.
Okay.
Where I think our argument really comes in is the very, very clear and unambiguous wording from Dr. Domer. Again, when we're dealing with medical reports, already anything in an arbitration context, we're dealing primarily with documents, certainly in uninsured and underinsured motorist cases. And so there'll be, at some juncture, room to hypothesize regarding the meaning of words, especially in medical records, where doctors are not sometimes as precise as they ought to be. However, we think when a doctor is completely precise, minimally, where he comes out very, very directly on points, we can't ignore that. Certainly, if he was ambiguous on the point, then we'd concede the issue also.
So, I'm sorry.
No, go ahead.
So when Dr. Domer, I believe Dr. Domer was I think I certainly give him credit for it, when Dr. Domer said that this was a transient increase as a result of a pre-existing injury before any pre-existing situation before any injury to the knee was sustained, we have to accept that because that's an opinion he gave at the mediation, correct?
He didn't, if I may, Your Honor, he didn't testify live at the mediation. It was by virtue of his report. I don't mean to add to that, but
Does refer to the problem as a transient increase as a result of a pre-existing situation.
he does.
Okay.
But if I may elaborate on that
Please.
point, thank you. The real issue is, with the reflection of time, people's joints wear down, things happen, and so any individual of a certain age or perhaps with a certain pre-existing pathology will have some symptoms or perhaps some pathology which is not symptomatic. What we're talking about here is an acute event and a direct surgery. In other words, what he doesn't say is that the surgery would have happened, perhaps Ms. Tesler would have had the surgery in 30 years from then, perhaps never. That's not addressed in his original report. What we're talking specifically about in this context is this particular surgery and these particular medical bills. And I was very careful, certainly in our papers, and I hope now as well, not to assert that the arbitrators ought to have given us any amount of general damages. In other words, that's within their discretion. They can find that she was minimally damaged because she had prior problems. This event occurred over time. What they can't say, though, is that those medical specials, those hard damages, were not directly caused from a medical perspective by this particular car accident. And I think that that's really key to our argument. And I don't, pardon me?
No, Counsel, the one additional confounding factor that I don't think we've talked about yet is effectively your argument is 2/3 of the panel, or maybe 1/3 of the panel, didn't properly hear, receive, or consider the evidence, and a claim that it's otherwise undisputed, but we don't have a transcript from the hearing. And I understand that Dr. Becker testified live and then provided a supplemental declaration, but to me I struggle with that for a couple of reasons. On the one hand, you want arbitration to be informal and low cost, so you don't have a transcript. But on the other hand, if we are effectively asking to review an arbitrator's award that it improperly failed to or otherwise consider evidence, and we don't have a transcript of the evidence, that seems like a bridge too far, perhaps.
Perhaps, and certainly it would have been nice to have had a transcript. However, I don't believe that Progressive, in these proceedings at least, has asserted, or even in the Superior Court proceeding, asserted that Dr. Becker was equivocal. I think we have consensus on that point. So although a record certainly would have been nice, I'm not sure it's...
But to have Mr. Marks go through this for us and say, here's the evidence that you should have considered, that suggests to me that the arbitration panel had that evidence before it, that it considered it, and that there was some rather strong disagreement among the panel members. That seems not to be what the legislature had in mind when it said that courts could intrude when the arbitrators fail to receive evidence. Here they're debating the evidence.
Unless Mr. Marks articulated his position and made it somewhat known what his position was, and the other two arbitrators were intransigent.
Intransigence, though, is not the same as the statutory standard. It is true that some people in all walks of life are intransigent, but that's not reviewable. I mean, they may, and that intransigence may lead one to error. They may be absolutely dead wrong, but again, for whatever reason, we've, as a society, decided that arbitration is the superior decision-making system, and we allow that sort of error to stand unchallenged.
If indeed the court finds that there was a proper aversion of their minds to the issue and it was summarily rejected rather than a mere failure to consider in any meaningful sense, then the court would obviously have made a valid point. If I may, just very briefly, because I'm running out of time, on the cross appeal, we respectfully submit that the judge was absolutely within his right to find that there would be no awardable costs or attorney fees. The case law is clear on it, the statutes are clear, that the judge is vested with broad decision, And the judge said not only did it not arise out of contract, but indeed it would amount to an undue or extreme hardship on Ms. Tesler for the court to make such an award. And I say this anticipating and addressing Progressive's argument. Unless there's anything further, if I may just reserve a brief amount of time for rebuttal.
Thank you.
Thank you, Your Honor.
Good morning, Your Honors. Colin Welch, I represent Progressive Preferred Insurance Company.
Was there any disagreement among the doctors in regard to what the causation was?
Yes, absolutely there was. You had three different causation opinions. You had one saying, yes, that was Dr. Becker on behalf of Ms. Tesler. One saying that there was no causation for the need for the surgery to the accident. That was Dr. Domer. And then you had Ms. Tesler's treating surgeon who did not have an opinion, couldn't form an opinion based on whether or not there was causation for the accident.
Then how do you address the statement that appellant's counsel is really hanging their argument on, which is that line in the affidavit or the statement that was made? How do you explain that?
Poor draftsmanship, for sure, I believe it is. But I think when you read that statement as a whole, that he's referring back to his prior opinions in his original report following his medical examination, in which he says this is a transient aggravation at best, and there's pre-existing conditions, and there's a congenital condition in her knee causing this problem, and doesn't relate the accident to the need for the surgery. And when the subsequent opinion that Tesler relies upon says that he does not change that opinion, and then goes on to admittedly poorly draft a sentence that has been read to have him revert and change his position from that original report.
Thank you.
From my perspective, I think this case primarily hinges upon the interpretation of the statute, the Uniform Arbitration Act, in play here, and whether there is any means to set aside the arbitration decision at this point. Obviously, the crux of the word that's been brought up, or the key word that's been brought up, is whether failure to hear evidence is something more than just admitting it and listening to it. And I believe that it's not. Admittedly, I was not able to find any other case law directly on point either, but I think if you read the Uniform Arbitration Act itself, it determines that position. If you look at 12-1505, the statute says the arbitrators may hear and determine the controversy. And I think that bifurcation of and use of those two separate terms makes it clear that hearing evidence is something different than making the determination on the evidence, and that's something that cannot be looked at as to what evidence supported and whether there's sufficient evidence to make the determination versus whether the evidence was just heard. The claim that the evidence as causation is uncontroverted is not true, both as to what we've already discussed with respect to the three doctors' opinions, but there's also multiple other factors and facts that the arbitration panel looked at in this case, any of which could have been the reason that ultimately led them to their conclusion. Number one being that the treating surgeon in this case, the very person that Tesler seeks damages for his treatment, does not know whether or not the accident led to or caused any need for surgery. And in that sense, the panel could have accepted that opinion and given the persuasion and the burden on the claimant could have found in our favor.
What's Progressive's theory, that this was all just made up and the accident had nothing to do with it, and she was simply trying to collect money for something that she would have done at the same time anyway?
Absolutely not. In the record and the facts that were presented to the arbitration panel, there were 2 slip and fall injuries prior to the subject accident. There's also a prior motor vehicle accident before this accident. In that prior motor vehicle accident, the emergency room records were clear that she injured her right knee in that accident, the same knee that she claimed a need for surgery after. She reported feeling a twinge in that knee at the emergency room. Also, at the emergency room following this accident, there was no diagnosis of any knee injury at that point. She then went on to exercise at the gym. She went on a skiing trip. And then she had at least 2 subsequent falls after this accident and before her eventual surgery on the knee. Prior to the accident in question, she had actually been referred to the same orthopedic surgeon for evaluation of that right knee. So there was facts supporting that this was pre-existed, and the need for the surgery, in fact, pre-existed.
All that was presented to the panel.
Correct, Your Honor. So, in light of the arbitration panel's discretion to reject any evidence or rely wholly or partially on any expert opinion, and that there's other evidence supporting alternative causation here, even if we were to reweigh the sufficiency of the facts, I think they still clearly weigh in favor that there's no conclusive evidence to support that this accident, as opposed to the several others, led to the need for Ms. Tesler's surgery. I'll move on, if I may, to the cross appeal and the 2 issues regarding fees and costs. I'll briefly go over the fees. Admittedly, the trial court has wide discretion to either award or not award those fees. The issue taken with the trial court's decision was that it from the record, does not look like it considered any factor other than the one factor argued of extreme hardship. And at least based on my review of the record, I couldn't find that any of the other factors were addressed. And my reading of the Warner case says the court should at least consider all those factors before coming to a decision.
Would you agree that this was a good faith dispute between the insured and the insurer?
I would, absolutely.
In that case, given Arizona's insistence upon equal consideration, why would the insurer seek to disadvantage its insured by asking for a fee award merely for pursuing a good faith dispute that came out 2-1?
I didn't know that it would be a disadvantage.
Well, I think anybody writing the check would think it was a disadvantage.
Understood. The fee award was just sought in due course. It was the belief that it arose out of contract.
But should insurance companies be doing that in due course in response to good faith acts by their insureds? I mean, if this was an abusive action, I would understand, but it wasn't. This we all agree this was a good faith dispute. 2 arbitrators came out one way, 1 came out another way. Under what view of equal consideration does an insurance company routinely, in due course, seek fees against the person who's paying its premiums?
It doesn't. And the only issue, the only thing that made fees arise in this case was the not accepting the arbitration panel decision, which the policy calls as binding, and pursuing it further into what I don't believe was necessarily a meritorious appeal to the trial court.
Okay.
Then the third issue I'd like to address then is the cost argument. Admittedly, I was not able to find any law to help the court with the decision of whether or not the fee award or cost award following confirmation proceedings is mandatory or not. I suggest that the provisions of the Uniform Arbitration Act do not intend to change 12-341 calling for cost awards to the prevailing party in a civil action. It is somewhat vague, but that section specifically doesn't address one way or another whether it's affecting or whether it's changing 12-34101, and let me explain what I mean by that. My review of other statutes that change the cost awards in civil actions, they all, from what I saw, change the way the calculation is done. For example, in a garnishment hearing, it makes clear that if a garnishee does not end up paying any of the, or escapes the garnishment, that they are entitled to costs at that point. In a replevin action, the person who serves a written good faith estimate, if it's not accepted, then and you don't do better, then that is that party is a prevailing party and is awarded their costs. Unlike all the other statutes that I was able to find, 12-514 doesn't do anything to change the relationship of the parties, meaning what party is the prevailing party doesn't come into factor to change who the prevailing party may be. So, looking at the statute of 12341, it does make the fee award mandatory, and I think what the drafters of 12-514 were intending, admittedly I was not able to find any authority on what the intent behind the Uniform Arbitration Act was, but it seems to me that what the drafters of that statute were getting at is itemizing what are taxable costs, such as Section 12-332 does. And the reason I get at that is because, unlike the other statutes that change the cost allocation by determining who the prevailing party is, this statute merely makes clear that those proceedings for confirmation are awardable as costs and can be taxed. I don't see that it changes the mandatory nature of whether or not costs should be awarded in this situation.
But there's that pesky may in there.
I agree, and that's where it was confusing to me as well, and that's why I started looking into the other statutes to see what they were doing to modify the shall that's in 12341. And all those other statutes that modified it included some kind of change to the basic procedural underpinnings and workings of 12341. That's why I conclude that the statute, the may in the statute, is there to confirm that those are taxable costs, as I don't believe that's clear from 12-332 that the cost of the confirmation proceeding can be claimed as taxable costs.
If there's one thing I think the legislature understands very clearly, it's what may means and what shall means. If they chose to use may, don't we need to respect that?
I agree, we do. I'm just not sure that the way they use may is in the sense of whether it's obligatory to award the costs versus whether those costs are included as taxable costs.
I've heard that shall can be merely directory. I've never heard that may can be obligatory.
And I don't mean it in the sense that may is obligatory. What I mean is that it's pointing out that those taxable costs that are included as that are incurred as a result of confirmation proceedings, those are taxable costs, just like 12332 sets out what taxable costs in the Superior Court are. And then the analysis becomes, now that we know what the taxable costs are those to be awarded to either party? And then we need to look at the language of 12341.
And I rather gather from your argument that that language, to your knowledge, doesn't appear in the Uniform Arbitration Act. That doesn't have as its source the Uniform Act.
The
12-15-14. The provision, costs of the application and the proceedings subsequent thereto and disbursements may be awarded by the court, that's not part of the Uniform Act.
If I understand correctly, the argument, the specific argument I'm making, no, is not part of the Act. I was not able to find anything that clarifies that.
Thank you.
The specific language of the Act, though, does make the costs of the application, it's a may for any action brought to confirm, modify, or change the award. In this case, the costs were sought under a different statute of 515, because what was filed was an application to oppose the award. And so if we do look at the strict language of 1514 and the change and how, and if we take the alternate argument that it modifies the compulsory nature of 341. It only modifies it as to applications when it's to confirm, change, or modify the award. And the statute in play that Tesla raised was the 1512 to actually oppose the award. And so the language from that statute does not appear to apply in the circumstance when someone attempts to oppose the award, as opposed to just modify or change.
And that's 1515 that you talked about just now.
Correct, Your Honor.
Thank you.
With that, unless there are other questions, I reserve any other time for cross rebuttal. Thank you.
Thank you. Very briefly, the Wilcox and Warner decisions do list certain factors, none of which is dispositive, and I think that we can safely assume that the Superior Court in its sound decision considered those factors necessary to give weight to its ruling and to support its ruling. And so I think that we can, at least on that issue, defer to Judge Ray's discretion and decision. Unless there's any further questions, I thank the court for its time.
Thank you. Do you have
Thank
any
you.
further? No. All right, we're going to take it under advisement at this time. A written ruling will issue in due course. Counsel, thank you very much for an interesting argument, and we stand adjourned.